Viewers, greetings. Last week, when I had done this video, we said that all the courts are going into vacation. So I expected that we'll be more going into topic-wise video thenceforth. But just before going into vacation, some important judgments came out, and some of them were pretty big in size. So we had to note them, and today's video is essentially based on those judgments. I would like to emphasize on one fact that in our website, the topics, the numbering, the serial orders keep on changing because we want to group them for your convenience. So the topic numbers, if you go to some old cases, the topic numbers may change. The topics remain, but the serial orders do change. So with this, we go on to the next part of the video. As you can see the Guide to IBC website homepage on your screen. Now, today we are going to discuss about 5 or 6 cases. And it's necessary that I should give you a background. Now, the first case we are going to talk about is on Kamla, Nehru Memorial Trust and another versus UP State Industrial Development Corporation Limited and others. Now, let me give you a background of this particular case. So what happened was Kamla Nehru Memorial Trust in 2005 or sometime around that, they had applied for 125 or 127 acres of land from UP State Industrial Development Corporation Limited, and which was allotted to them for doing floriculture. They had paid some money, allotment money, but then they immediately, and allotment letter was given, but thereafter they stated that the land was encroached. They did not pay the reservation money. They complained, and when UP Industrial Development Corporation, they wanted interest. They said that interest is not payable. So again, protracted exchange of mails went on, and thereafter they paid the reservation money, and they wanted possession of the land. This process, and UP Industrial Development Corporation said until and unless the deed is executed, the lease deed or sale deed is executed, it cannot get. So ultimately, the matter went to Supreme Court in 2025, and the decision came this week itself. So what Supreme Court said, now let me share the screen with you once more. Sure. The Supreme Court stated that protracted disputes highlight the need of more stringent initial evaluation process to prevent chronic defaults. It took 25 years' time. Court also said that such protracted disputes highlight the need of more efficient, stringent initial evaluation process to prevent chronic defaults. The allocation of 125 acres of industrial land, the allocation of 125 acres of land, industrial land to KNMT without competitive process fundamentally violated doctrine, which demands proper procedure and substantive accountability in public resource allocation. This also created a system where privileged access supersedes equal opportunity. This betrays the fiduciary relationship between state and its citizens. This also why we included this has got nothing to do with insolvency bankruptcy code. But if we come to liquidation also, let us see let us see Schedule 1. So in Schedule 1, Topic 53, we say that with respect to sale on as is where is basis, in terms of legal doctrine or caveat emptor, it becomes the duty of the buyer to exercise due diligence. So in this particular case, Kamla Nehru is featuring here. The UP Industrial Development Corporation said that this allotment was on as is where is basis. And Supreme Court noted the allotment letter had a site map. So there was no necessity. The trust was inquiring about asking for survey and all that, but that wasn't necessary because it was already there and they had seen the land. And the question of possession would only arise if the land would get, there would be a sale deed executed. So this is not only just insolvency bankruptcy court. When we are dealing, this particular website is not for insolvency professionals only. This is for the entire fraternity, even for CDs also, even for banks and everyone. So we should know, or not only focus to insolvency bankruptcy court, but we should be aware of entire circumstances. Now we will go to a case. This is a small case, but a peculiar case pertaining to Section 9. We know operational creditors. Now, this case is Drive India Enterprise Solutions Limited versus BGM Telecommunications Private Limited. In this case, what happened was this operational creditor had applied for, filed a petition under Section 9. And Section 9, and let me go to this. And the court decided, the court earlier also, this particular operational creditor had applied for insolvency, filed other two Section 9 petitions, which were both rejected. So court, based on its experience in earlier two occasions, said that this petition is also rejected. So NCLAT was of the view that the tribunal has not deliberated upon the facts of this case and evidence has simply relied on earlier decisions dated 15/11/21 and 14/9/23, which are against different CDs, which has no nexus to the present case. It was incumbent upon the tribunal to have referred to the facts of three cases in detail, which they have not done. And this was against the principle of natural justice also. So, in short, the court said that application filed under Section 9 has to be decided on its own facts. Now we are going to another case, which is a very interesting case of Anuj Kaur versus Ravindra Kumar Mistry. Now, in this particular case, what happened, this was a case going on for almost 10 years. Now, in this particular case, this pertains to a homeowner case, home buyer's case, wherein the home buyers, the COC had stipulated a different eligibility criteria for home buyers. And home buyers submitted their resolution plan, and the resolution plan got accepted. Of course, there were allegations of mismanagement and fund siphoning by the developer, but we are not going into that. But the case basically states that COC can. Now, let us go to Guide to IBC. Anuj Kaur is section, let us go to, this is in section 25, as well as you can see it in, I would rather take you to 36A, because 36A would give you a better idea. In 36A, we know if we go into topic 16, the expression specified criteria for prospective resolution applicants cannot be read to mean that criteria for all prospective resolution applicants have to be same. So COC has the right, and this we know that we had seen earlier that in Crown Business Park Bar Association, the COC had given a different eligibility criteria for homeowners. And even in this case, the COC had given a separate eligibility criteria for home buyers, and which was accepted. Which was accepted. Now, what is important is this. Now, there were, and the SRA had given 4 contingencies. Now, this is very important. Let us go back and let us go back to section 30. Topic 74, I think. Yeah. Contingencies are alternative options under which the resolution applicant must carry out the construction in accordance with the requirements of law. Thus, the resolution plan cannot be termed as conditional. Now, in this case, what happened was UPSDC or whatever the body which had provided for the land, which had provided land, they had stopped the project. Because the project, what had happened was the developer had vitiated, the developer had not gone through the land, and there were various, I would say, discrepancies. Now the SRK or the home buyers, they had suggested 4 contingencies which could be considered. And fortunately, the controlling agency, they accepted the contingency number 4. So herein the court stated that contingencies are alternative options under which resolution applicant must carry out the construction in accordance with the requirement of law. Thus, resolution plan cannot be called conditional. Now, another very important aspect which was touched upon in this particular case is pertaining to Regulation 31A. We know about 31A, so regulatory fees. Now, in regulatory fees, in explanation, what it is mentioned, for removal of doubts, it is hereby clarified that the regulatory fee under this subsection shall not be payable in case where the approval of resolution plan in respect of insolvency resolution of a real estate project is from association or group of allottees of such estate projects. So the court Enclad stated that the explanation to Regulation 31A clarified that in respect to insolvency resolution real estate project, association or group of allottees in such real estate project also can submit resolution plan. So this is a very important case, which is an exception by itself. Now we come to another very peculiar case. It's Dr. Vichitra Narayan Pathak versus Suraksha Realty Limited and another. Now in this case, there are multiple facets. If I want to discuss about this project, the entire this podcast would last for about an hour or so, or maybe more. This pertains to gold and tobacco. What happened? Gold and tobacco was declared as a sick unit under BIFR. BIFR had given a scheme. State Bank was the main agency to control the scheme. Now, the company had a huge plot of land in Mumbai. So they got into without telling the banks, they got into an arrangement with developers to develop the land. And this development and thing would have, if it really materialized, it could be worth about 700 to 1,000 crores. Now, for giving this particular award to the developer, the company got 133 crores, for which giving 133 crores advance, the developers lodged a claim and they said that they're secured creditors. They're secured creditors. Now, in the process, when it went to NCLT accepted. I mean, the RP had rejected the claim. The NCLT did not only say that the claim was correct, they admitted the claim and they said that this is a financial creditor and this is a secured financial creditor. And in turn, they said that the RP, who used to be an employee of central bank, has inflated the claim of central bank. They removed the RP, appointed a new RP, and obviously, and they reduced the claim of another uh, financial creditor. Now let us go back to let us share the screen and go back to IBC. Now you can see the screen. Now first question is what is let us talk about what is this, whether secured creditor or not. So let us go to section 3 subsection 30, secured creditor. Now the court said that the key word for mortgage by deposit of title deed is the with the intent to create security interest thereof, according to section 58F of Transfer of Property Act, Dr. Vichitra Nayan Pathak. So it said that the corporate debtor was aware that there was a scheme and they could not create a mortgage. The developer was aware that there was a scheme and they could not create the mortgage. So just by keeping the deed, it did not mean anything for that purpose. There was no intent to create mortgage, though some kind of a right they thought it was, but it was not definitely mortgage. Now, this also said, now we go to section 27. The adjudicating authority has power to replace resolution professional while exercising power under Rule 11 and Rule 11 and Section 60, subsection 5, even though there is no resolution by COC under Section 27 of Insolvency Bankruptcy Code. But such power has to be exercised rationally. You cannot, the adjudicating authority cannot act in an arbitrary manner and remove the RP for no fault of his. The RP had done nothing wrong. So NCLAT had turned down had set aside the order of NCLT of removal of RP. And they said, sorry, this is not done. The old RP, the RP was functioning, is reinstated back. And just that he was an employee of Central Bank of India. There was a complaint also in IBBI. IBBI gave a clarification stating that you should be careful henceforth. So there was no punitive action taken against the RP. So that wasn't a ground. So NCLT took a stringent view against that. But what is important is, let us come to Regulation 13. So there are two. When an adjudicating authority has determined a claim in CIRP of corporate debtor, the finality to such determination must be attached unless the said decision is modified or set aside by an order of a competent court. So, adjudicating authority had said that these two developers' claim was that of a financial creditor. So, the claim was admitted, which wasn't challenged in NCLAT. So, this particular thing was or had already attained finality. Even with regard to any decision in CIRP, so long it is not challenged in the competent court, it attains finality. But at the same time, court also said, and court also allowed 18% interest in the agreement between corporate debtor and the developers. It was mentioned that the money which they had given would carry an interest of 18% per annum. Since it was an agreement between corporate debtor and the developer, it was in writing. So the court said that if interest is agreed upon in writing by lender and the corporate debtor, accrued unpaid interest constitutes a valid claim. The adjudicating authority cannot now pertaining to coming to the two matters of reduction of claim or stating that central bank's claim was uh, inflated. So the court was of the view that this was a case, this IA was pertaining to whether the claim of the developers were which was disallowed by RP, that had come in NCLAT, or this was being seen by the NCLT. In doing that, in that particular IA, it was the other financial creditor or central bank was nowhere mentioned. So adjudicating authority did not have the locus to state that disallow the claim of Arrow. There were two cases. One was of Arrow Engineering. So they disallowed the claim. They reduced the claim by 40.75 crores, which was beyond their jurisdiction. And in central bank's case, they said that sorry, your claim is inflated. So how can you say when you're dealing with another matter, you cannot mention that? Now, this is an important thing. We have to come to section 60 also. Yes. Topic 1800 and 101. NCLT must follow rule of natural justice and afford opportunity of hearing to respondents. Obviously, in central bank in Arrow, there was no Arrow Engineering, there was no opportunity provided. In 100 and 101, when adjudicating authority has determined, what I said that has determined an issue in CIRP, corporate debtor, the finality to such determination must be attached unless the decision is modified or set aside by competent court, which I've already told you. The verdict of adjudicating authority must relate to IA being heard. A remark on matters not under consideration is ultra vires. In Central Bank of India, inflated claim and Arrow Engineering 40.75. This was ultra vires. So this is a very peculiar case, and we should look at it. I mean, I am not going into detail because going into detail would consume a lot of time. So I would request the viewers to please go through the details, and that will be important. We'll come to another case of Wakai Hospitality Private Limited versus Miss Palak Desai. Now, this is again a peculiar case. And with this, what happened was there was a tenant to whom a plot was given to run a restaurant. And there was a time also allowed that this particular facility would run for so many years. The tenant did not pay rent. So the RB came, he terminated the rent agreement and said, and NCLT upheld RP's argument. Now it was challenged. It was challenged by the by the by the tenant. Now let us go to section 14. The main challenge was that since the company was under section 14 moratorium, how could the RP terminate the rent agreement? So the court said that while it is permissible, it is impermissible to deprive third parties of their rights solely on the basis of the initiation of insolvency proceedings. There is no prohibition on terminating agreement in accordance with the contractual terms during CIRP period or even thereafter. The CIRP moratorium is for protection of the CD, not for a third party. So NCLT told Wakai Hospitality, I mean the tenant, that sorry, my dear, you are a third party and Section 14 moratorium is not for your protection. It is for the protection of CD, and by not paying rent, you cannot stay here. So if the court has said that you vacate the premises, you better vacate the premises. The company had gone into liquidation. Naturally, it was the liquidator then who was moving the petition. So under Section 35, the liquidator should get possession of the properties which are owned by the corporate debtor. So the possession was given to the liquidator. So I'm not going into the liquidation part, which you can see. Now we are going into another case of Bhavik Bhimjiani versus Uday Vinod Chandra Shah. Now in this case pertains to private sale. There was an asset of corporate debtor. The liquidator had auctioned it thrice. Those days you could do auction one after the other. I mean, now that in 32A you will see, or Schedule A, Schedule 1, there's a time limit mentioned. Those days, such stringent timeline was not there. So it was basically a very quick succession. Three auctions had taken place, and thereafter the property was sold to a related party at 58 crores. The other party, the other stakeholders, they came to the court and said that this is not proper. So the court, let us go into this particular case. This is Regulation 33. So let us go into Regulation 33. Topic 3. Topic 14 and 15. The liquidator must follow steps stipulated in Regulation 33 of Liquidation Regulations and make disclosures in case the sale is made to related party. Now here what happened? Court says what? Before you do the private sale, you should come to NCLT and take permission. Here the liquidator fixed the price, got the EMD, everything done, and thereafter they went and did not even mention that it's a related party. So the court was of the view that this is most improper. The liquidator did not follow the norms stipulated in Regulation 33. So this sale was absolutely improper, and also court held. Let us go back to another topic. Court held that the price was undervalued. The initial value was taken to be 63.8. The two valuation liquidators said, sorry, the Schedule 1 allows me to reduce the price by 25%, and thereafter 10%, 10%, which I've done. So court said, no, it's not the question of adequacy of, it is not the question of adequacy of price found in the auction, but it is the procedure which needs to be followed in liquidation process regulations, transparency, and also discovery of maximum recovery. In liquidation regulations, liquidator is supposed to draw up a strategy of marketing. Where is the strategy? You sell to a related party. Where is the strategy of value maximization? There was no strategy made. It was just going and selling, and there was also other irregularities like the the staffs of the directors. There was a common director also. So the beneficiary was somebody. So it was the liquidator was eventually removed. So this is a very important case, which I think you should also note, which you should also know. And with this, we come to the end of this short video, and we go to the next part of our video. Thank you. We have come to the end of this video. I hope you enjoyed it, and I could learned some new traits about insolvency bankruptcy code. Hope to come back to you again next week with some new inputs, or maybe some we can discuss on some topics. So bye for now.